Hi, everyone. Harry here to talk about everyone's favorite circuit, the Fifth Circuit, and their very controversial new decision jettisoning years of precedent and holding that Section 2 of the Voting Rights Act, the small vestige that still remains after the Supreme Court has hacked away at the Voting Rights Act, may not be used in a situation where you are combining the numbers of two different minorities, in this case, blacks and Hispanics. All right, that's a little bit of a mouthful, I know. Let me double back and explain. The Voting Rights Act, passed in the 60s, may be the high water mark of civil rights litigation, and among other things, it gave the Department of Justice very strong enforcement power to go after states who had a history of discriminating on the basis of race. And the Supreme Court just eviscerated it, just wrote it out a term or two ago, saying we are no longer this assumption of bad conduct based on what they've done in the past is no longer viable. Bye Section 5. And that leaves essentially only Section 2, which the court has said still does apply, and that applies when you intentionally racially gerrymander. So you take a state with 40% African Americans, say, and you very carefully draw the lines so that every single district has only a minority of minorities, and therefore you're unlikely to elect a minority member of Congress. The court has said, no, that kind of racial gerrymandering doesn't fly. You need to construct maps that give a district or two, or, close to anyway, the actual proportion of percentage in the state of the minority group. So a classic one would be, one other point, the court has said that it won't really actually look at gerrymandering claims. So the Section 2 enforcement mechanism is much weakened. But essentially, you have a state. It's got, say, 30% African Americans, and you're going to be dividing it into 5 congressional districts. That's just arbitrary. It's based on population. Basically, you better be sure that one or two of them, that you don't draw the line so carefully that you've ensured that there's no such thing as a, quote, majority minority district. That is to say, a district, a specific geographic area that elects a member of Congress that is majority minority. Now, often states have responded by drawing ridiculous, exquisite shapes, but almost all minorities or African Americans are sort of housed in this crazily drawn district. But the court says that's okay if you're not specifically trying to disenfranchise minority groups. The question in this big case that the Fifth Circuit decided yesterday is, what about if a majority, the Republicans here have taken tremendous advantage of winning or kind of maneuvering to control the process and draw very politically divided, very politically gerrymandered state maps all in all, but here's a place where they can't go too far, that is to say where race is concerned. Okay, but what about if you do, as in fact they did in Texas, draw a map where a lot of Hispanics are in one district, but they're still outnumbered. A lot of African Americans are in another, but they are still outnumbered. So in this case, a coalition of black and Hispanic voters sued under Section 2 of the Voting Rights Act and said, we have been, dismissed, or we have been effectively gerrymandered out. So it raises the question, does Section 2 recognize a claim based on a coalition of or a combination of more than one minority group? Okay, That's a pretty complicated legal question to state it and to set it up, but not to decide it, because in the Fifth Circuit, the law was very clear that the answer is yes. You may not, that you can have a challenge where different minority groups come together and a majority can't gerrymander them away. So that's exactly what happened here. The Galveston County Commissioner's Court had a new districting plan just for county commissioner elections in Galveston County, and it eliminated the only majority-minority precinct, which they'd had for, some 30 years, because what they did was take a precinct where that it was a majority of minority voters, blacks and Hispanics, redraw the map so the black citizens were here, the Hispanics were there, and there's no majority district of minorities. So they sued. To take a step back, the Fifth Circuit, and I was a little bit flip at the beginning, but it is the circuit that was spanked repeatedly by the Supreme Court this term, and that is really, even by the measure of the Supreme Court and the courts today, really a out there, outlying circuit that is very conservative, even cuckoo. Okay. So that's where we are, the trial court. But the Fifth Circuit had already held in a case called Baytown in 1988, you can do this. And many other circuits have had similar holdings. So when they brought this claim, the district court said, yes, you can do it. And then when it went up to the appellate court, the Fifth Circuit, a panel of 3 judges said, yes, you can do it. But then it was taken en banc by a majority of the judges, and basically in essential party line, all of the dissenters are appointed by Democratic presidents here, and it's a very bitter dissent. And the majority is written by Edith Jones, who is a long-time notorious judge, very, very conservative and known to be activist. Okay, she writes an opinion that basically overrules the old one, and she it purports to be based on plain language. What's that plain language? Well, there is a section of the Voting Rights Act, and Section 2 says you can't do a sort of drawing of districts in a way that results in a denial or abridgment of the right of any citizen of the United States. And she says, look, that doesn't. You can't combine citizens there. You either African American voters have been abridged or Hispanic voters, but you don't put them together. And so far, you understand what she's saying, and then you come to the dissent where 5 judges of the Fifth Circuit, all Democratic appointees, and they really beat up on her badly. They show that the legislative history was such that the Congress had, as I said, in 1988, the Fifth Circuit, among many circuits, it said you can do this. And there's legislative history where it's clear that Congress has accepted that you can do this. Now, Joe says, we don't do legislative history stuff here. But they have the language as well. And they have really very strong, they're separate dissents, but then the sort of 5-person dissent says, today the majority finally dismantled the effectiveness of the Voting Rights Act in this circuit, leaving 4 decades of en banc precedent, that's what I was telling you about the 1988 case, flattened in its wake. And it is atextual and ahistorical, and essentially to the statutory term of person, the dissenting judges talk about the language in the Voting Rights Act about classes of voters, and classes of voters easily encompasses more than one racial group, and moreover, it's there's a little bit of a split. I believe the Sixth Circuit has maybe gone the other way. But essentially, there's just quite a lot of precedent, especially in the Sixth Circuit. As I said, the Baytown case really expressed, of course, a en banc court can overrule, but a strong statutory argument based on classes of citizens rather than the language that the Judge Jones and the majority point to of a single voter. So this is a big deal. It essentially takes away one of the very few remaining vestiges of a viable attack under the Voting Rights Act. The most important by far was Section 5, but Section 2 has still remained for the most rank, crazy, exotic map drawing that disenfranchises minority voters. And the law, even in the Fifth Circuit and elsewhere around the country, has been that you can combine different minority groups. Probably now this is a issue that goes up to the Supreme Court. It seems pretty clear there's a circuit split and a very bitter kind of back and forth in this opinion. And of course, if it does, if you're a betting person based on what they did with Section 5 and have done with voting rights in general, you would not be very sanguine about their staying the course on the what is the prevailing rule now, that you can combine minority groups. If it goes to the Supreme Court, the betting line would be that they will take the position of the Fifth Circuit and say you can do this as long as, or challengers cannot try to lump together different racial groups. So we'll see if that happens, and if so, one of the final sort of tendrils of the what had been the tree of the Voting Rights Act will have been cut. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.